Lesson 8 is about corporate management. In other words, okay, we've got a corporation. Now what are some of the rules that govern its management from day to day? Well, we've got three basic components of us in the power structure of a corporation. You've got the shareholders who own the company, you've got the directors, and you've got the officers. Now, of course, both can be both. One person can play both roles, and we've discussed all this before, but now we're going to go into it in a little bit more detail about the roles of the various of these three different groups. Let's start with the board of directors. The board of directors are really in charge of the corporation, except some major decisions that are made by the shareholders. Some of the things that the directors do, they hold annual meetings. States actually require these annual meetings. They could be done live, they could be done by phone, they could be done by teleconference, but they do have to be done. They can call special meetings when there's something important that's going down in the company. They can create committees regarding particular issues that are important, study particular issues. They can hire and fire officers. The officers of the company, the executive officers, or really any officers of the company, serve at the pleasure of the board of directors. The board of directors can hire a president, and the board of directors can fire a president. And they can make recommendations to shareholders on major issues, like whether to dissolve, whether to merge, that sort of thing. Board action is accomplished by a majority vote, but in a subcommittee, if you have 9 members of the board and they say 3 people will study this particular issue, well, those 3 people cannot act on behalf of the board because you need a majority of the whole board. Corporate officers, on the other hand, are people that manage the day-to-day corporation. Examples, of course, the CEO, the Chief Executive Officer, the CFO, President, Vice President, in-house counsel. These are all people that are at the head of managing the company. They're not the directors. They don't make the major decisions, but they make the day-to-day operating decisions. Officers, one thing that distinguishes an officer from another employee, obviously the officers are employees of the company, just like people who work on the assembly line or the custodian or whatever. Everybody else who works for the company is also working for the company. But there are some distinctions between officers and directors. Officers and regular employees. First of all, officers have authority to bind the company. An officer can sign a contract and make an agreement on behalf of a company, whereas a regular employee, a lower level employee, cannot. Officer has speaking authority for the company. If an officer makes a statement, that is considered a representation of the company. The company could get in trouble for misleading or false advertising if an officer makes a statement that later turns out to be not true. And officers have an obligation to report to the board as the shareholders regarding the status of the firm. And the nature of this is governed by securities rules, the Securities and Exchanges Commission rules. Lower level employees may work for the company, they may get a salary, but they don't have a duty to report and they don't have the authority to bind the company with a statement that they made. Some other responsibilities are the fiduciary responsibilities. Now, these are owed both by directors and by shareholders, and we've discussed all of these before when we discussed partnerships, so some of this is going to be a little bit of review. This requires that officers and directors act with reasonable care and diligence. You have the duty of loyalty and the duty of care, and now we are discussing the duty of care. A breach of the duty of care, which means a breach of the responsibility to act appropriately, can be misfeasance, in other words, taking actions that are harmful to the company, taking actions that are unreasonable, buying things that are bad or objectively bad investments, not just bad judgments, but making decisions that are bad for the company. And then there's nonfeasance, which means failing to take action that a reasonable person would take. Misfeasance, for example, if I was in the board of directors of a coffee manufacturing company and I decided to buy a line of cars or a car dealership that I knew nothing about, but because I thought it was a good idea, that might be misfeasance, whereas nonfeasance would be, let's say, failing to file the tax return for the corporation on time that I was supposed to do, and because of that, the company got hit with a fine or the company got hit with some bad consequence. These responsibilities are objective, which means every corporate officer and director is expected to adhere to the standard that a reasonable person would normally be expected to adhere to. In other words, an officer and director is expected to have a reasonable level of competence in acting on behalf of the company, and it also takes into account the person's experience and training. Obviously, if a corporation hires an executive officer and pays that person a lot of money because the person has a PhD or the person has 20 years of experience managing companies, well, that's part of the reason why the person was hired. And because of that, that person now has a responsibility that is commensurate with the person's experience. If I'm a 20-year CEO and I make a bad decision, well, that might not necessarily have been such a bad decision if I were a rookie, but I'm not a rookie, and that's why I get paid the big bucks. CEOs very often of big companies get paid huge amounts of money, tens of millions of dollars a year, sometimes even hundreds of millions, and they get paid for that. Part of the reason is because they have this big responsibility, and if they mess up and they cost the shareholders hundreds of millions of dollars, they can get sued for hundreds of millions of dollars because the director officer will be liable to the corporation for harm suffered as a result of this breach of care. However, there is one major caveat to that, and that is the business judgment rule. The business judgment rule says, and it protects both directors and officers, it says that if the company makes a good faith decision that was based on due care, that was based on reasonable research, that was based on reasonable behavior on the part of the decision maker, and it turns out to go bad, just turns out to be a bad decision, that does not mean that there will be liability. It says if the director or corporate makes a corporate decision in good faith, the court won't second guess that decision. It would not be a good system whereby everything that turns out bad causes the corporate officer or corporate director to be sued for tens of millions of dollars because the shareholders lost that kind of money based on the stock going down. If that were the case, well, then no corporate director or corporate officer would take any risks. They would just be extremely conservative because they don't want to be sued. So the business judgment rule kind of encourages corporate directors and officers to not be reckless, but to be bold in their actions. And therefore, just because a decision turns out to be a bad decision does not inherently mean the duty is breached. So the business judgment rule applies in all cases. Just because you make a bad decision doesn't mean you're liable, except in some of these circumstances. Number one, where you haven't been reasonably prudent. If you haven't done your research, if you haven't done your quote-unquote due diligence, well, then you're not protected by the business judgment rule. Or if you haven't adequately researched the transaction, that also is a reason why the business judgment rule would not protect you. Again, if the business judgment rule doesn't protect you, well, then you can be liable as a corporate director or officer if the corporate shareholders lose money, which usually happens when you're talking about a bad decision on behalf of a corporation. It also doesn't apply when the officer or director acts in bad faith, in other words, knows it's a bad decision, or takes bribery or something to that effect. Certainly, a business judgment rule would not protect the officer or director. The officer or director has breached the duty of loyalty or has a stake in the transaction. Either of these cases. Duty of loyalty, like we saw earlier, when you usurp a corporate opportunity, there's an opportunity that comes to your attention by virtue of the fact that you're an officer in the company and instead you take it for yourself, the business judgment rule doesn't protect you. When you have a stake in the transaction, if I'm the director of a company and I personally am selling a house to the company, well, then the business judgment rule doesn't protect me. There's a conflict of interest there, and the deal better be fair in order for me to avoid liability.